So let's go to the estate planning mistake number 10. Failure to set up a buy-sell agreement as part of your succession plan to limit the marketability of the stock ownership being inherited by the family members and to control how the buyout price is to be determined upon death, disability, termination of employment, or other triggering events. That's a mouthful. What's it mean? Well, you can leave stock to your children, okay? Let's say you do. You have no plan. You have no buy-sell agreement. Just leave it out. I'm going to leave it to my kids. Well, they can. Each child can do whatever they want to. You know how your children get along really well together? All of them? And they can say, when I die, I'm leaving it there. All of a sudden, the in-law is in business with your children. And that will happen. Okay? Now, you can have a buy-sell agreement that says that when you leave the stock to your children, that they agree that is part of the deal, that when they accept the ownership of stock, that they're agreeing to the buy-sell agreement that mom and dad have put together that controls who can own stock in the company and who's bought out and at what price. That's the other thing, because that's part of the deal too. Some clients are saying, well, I gave them the stock. I don't want them to get a windfall. So they're trying to figure out how to split up everything to be fair to the children. You float that boat. One child gets the company, the other children get cash in the real estate. Who won? Well, it depends. I've seen it go both ways. The children are acting in the business. They got to make the business work. They got to make the succession plan work, and they might have nothing at the end of the day. And the other children got the cash in the real estate. Sometimes there's real estate involved in the business. So we try to have the real estate. So I've had clients who have the real estate go to the children not in the business. We try to do a long-term lease to protect the business so that the children with the real estate cannot extort and charge excessive rent for the family members that they're jealous of. They're being successful in the business because the business ended up being successful, so they don't want fair rent. They want their share of the pie, so to speak. We've seen all kinds of scenarios play out. The purpose of the buy-sell agreement, then, it will control which triggering events is going to require the family members to have their stock bought out. Death, disability, it could be termination of employment. It could be, what if they stop working? We have that where, not when they're terminated, but they could be terminated by the company for not doing a good job, or they could be out there, not doing anything. And so they've kind of retired, so to speak. So we do try to work through the triggering events is what we call them, and then we try to identify what's the valuation price going to be. As a CPA, I serve as an expert witness in divorce cases valuing businesses. Been doing it for years, so I'm helping clients when they put a buy-sell agreement together, coming up with a strategy to identify what the buyout price should be. Should it be a formula? Should it be a set price that is agreed to annually by the owners of the company? And there's a default provision. If they can't agree, then we have an appraisal process that kicks in. So we have a lot of different strategies that we use, and every business is very unique. So we have to try to come up with a plan that basically we're looking at the family, the parents are leaving the business to their children, and they want to control then how that buyout price is going to be computed. And they can lock it in, and it's their decision. We have some clients that said, you're giving it, so you're only going to get $1 when you leave. If you're active in the business, we have some clients say you got to be active in the business, and if you're not active in the business, you got to turn your stock in for $1, or for whatever value they determine. Any other questions? Taxes, succession planning, estate planning. We're getting near the end of it. Yes. Kentucky law controls, okay? You might have ancillary, they call it ancillary probate jurisdiction over in Ohio, but that asset really is governed by the laws of Kentucky as to how it gets divided among your children. You need to go to probate court in Ohio to get the property transferred to them, but your will under Kentucky controls all your assets, even though it's in another state. That was a good question. Any other questions? We're getting here. Yes?
Section 179, is there one for 217? If there is, what's the maximum amount? Deductions, section 179.
Okay, section 179, the maximum you can take in any year is $500,000 a year. And there's a phase out if your assets that you purchased during the year are more than $2 million. So for most small business owners, you don't have to worry about it. It's just so large. It has to be new equipment, by the way. It cannot be used equipment.
So it is available for 2017?
That is correct. Okay. Yes, exactly. And that is in the tax guide. It talks about that. So there's a page number reference there, too, on depreciation. Okay? Any other questions? Well, I'm glad you were here. Oh, yes.
The government, the Congress, for years has been talking about tax reform. And now with our new president, do you think we're going to see a lot of tax reform in 2017?
Let me share with you, this is what the senators and congressmen have been talking about the last couple weeks on the Sunday morning programs. I'm glad you brought that up to wrap it up here. As far as the Trump program, they don't expect to vote on any legislation until the end of August, the summer recess. So it's not going to happen in the first 90 days. He's got other agenda items on his plate. What we do know is that Trump wants there to be an incentive for businesses, because what's driving this is that the corporate tax rate is 35% for businesses, and that's the second highest rate in the world. So Trump wants to reduce it to 15%. The Republicans want to, Ryan is 20%, the Democrats are 25%. Okay, it's going to be somewhere, I think, in the 20 to 25% range. What that means for business owners is they cannot discriminate against just corporations against everybody else, but we don't know what's going to happen. They also do not know whether the changes will be effective this year, retroactive to January 1, or beginning January of next year. So you'll have to kind of just keep following the newspapers and the press and see what happens. It's really an open book. We do expect there to be a change. We just don't know when it's going to happen, whether this year or next year. And we don't know the exact details, whether it's going to cover sole proprietorships, partnerships, S corporations, to what extent, versus C corporations. So that's kind of the snapshot of where we are right now. Just a lot of uncertainty, but we are expecting there to be a tax break this year.